All right, everyone. It's about 11:59. Oh, it's exactly noon now. We're just going to wait a minute or two more for people to get on, and then we'll get started. All right, it's 12:01, and I think we're going to get started because we have a lot of ground to cover. My name is James Cousins. I'm a partner with the law offices of Melissa Day. Co-presenting with me, my friend for LOMAD and Friends is our law clerk, Brendan Shannon, soon to be our newest attorney. He is, as I affectionately call it, an attorney in waiting. So he should be showing up on the letterhead next month and at a hearing near you in the next couple months. So thanks for joining us, Brendan.
Great to be here. Thank you for having me.
Oh, our pleasure. And before we get started, I just want to remind everyone that this presentation is for educational purposes only. Nothing herein constitutes legal advice, although we're going to be discussing legal topics, legal standards, and a lot of case law. And although many of you are already wonderful clients of the law offices of Melissa Day, nothing herein constitutes the creation of an attorney-client relationship. Although we hope that if you are not a client, after seeing the presentation, you will agree that you probably want us to represent you because we know all this good stuff and we do a great job at being on the cutting edge of workers' compensation law. So we're not even going to take time for the normal pleasantries and our music. We're just going to jump right in because we got a lot to cover. The appellate division, we're busy bees this year. So all you folks that know me know that I like to talk about cases that I handled. So we're going to start off with one. We're going to start off on a high point. Gronica v. Town of Hamburg. Law offices Melissa Day gets the board's denial of appellate review under 300.13 reversed and remitted. This is an interesting claim because it came during a period where the instructions on the 300.13 RB89 form, as well as the regulation itself, simply indicated that when you had to indicate your exception, that's box 15, it only asked for you to tell the board when you did it. And in this case, we said when we did it was, quote, at the hearing. And the board said, no, that's not specific enough. We wanted the date of the hearing. And LOMAD said, no, that's not right, because you only said when. If you wanted a date, you could have just written date of the hearing. Interestingly enough, after this appeal was filed with a third department, the board revised its instructions, now indicating that satisfactory answer to item 15 as to when the exception was noted must state the date of the hearing at which the exception was noted. And interestingly enough, again, after we perfected this appeal and the Attorney General declined to file a brief on behalf of the board sua sponte rescinded its decision denying review and took the case on the merits. There were at least two other claims decided, one of them from the State Insurance Fund, filed at about the same time, that ended up with the same ruling. They cross-cited to our file, Gronica. However, the board, as I said, did subsequently change the rules, so now a complete answer to item 15 on RB89 has to include the date of the hearing. So we all know 300.13 has just been tragic, and our observation was that I think about at least 40% of the published decisions from the third department came down on 300.13 issues this last year. It's incredible. The volume is, of course, because each of these claims constitute a potential claim for malpractice, among other things. Certainly can't help attorney-client relationships, certainly can't help the handling of claims when meritorious issues are being denied review. So there are a lot of appeals still being taken to the third department. Despite that fact, the third department is holding firm on affirming most of the board's activity in this matter, which is, of course, disappointing. That said, we move on to the Noreen case. Noreen is interesting because in Gronica and in many of the other appeals that I looked at where I went and found the brief submitted to the court, parties were arguing that while one section of the RB 89 might not have the information that the board wanted there, other sections of the form did. For example, the form requires you to list the date of the notice of decision from which the appeal is being taken. So if you're listing the date there, why do you need to repeat the date in other places? In this case, that argument was set forward with respect to item 15, but only insofar as item 15 asks you to list when you noted the exception, but also the nature or the exception itself. Essentially, what is the issue? And in this case, the appellant noted that, the issues noted in section 11 and 12. Section 11 and 12, as we know, asks you to tell us what the issue is on appeal and what the grounds of the appeal are. And it is literally 3-4 inches away on the same sheet of Form RB 89. I mean, it's there when you're looking at it. They made that argument to the third department, and the third department bought it. They said that it is sufficiently specific to refer to the other section of the RB 89 with respect to what the nature of the exception was. I'm really nervous about this decision. We're not going to change our process. We've always trained our attorneys that, at the hearing, you're going to note a sufficiently specific exception. You're going to state the specific ruling to which you're noting an exception. You're going to restate the grounds of it, and you're going to do it again here too. You don't want to have to go to the third department to make this point. Somebody had to, the board lost it. My notes is that this is sort of confusing. This argument was presented in Gronica, and the third department didn't pick it up. Because our position was we didn't list the date of the hearing in response to item 15, but the date of the notice of decision is listed 4.5 inches away on the same form. Again, the board didn't reverse on that fact. They reversed on the fact that the board's denial was arbitrary and capricious because we had already satisfied the temporal requirement of when, in air quotes, by saying at the hearing. And if the board wanted something more specific, they needed to say so. I don't know.
James,
Yeah.
I've actually got a question on this case. So, in reading through the case law update, with 313, it sort of seems like the board's approach is it's my way or the highway, and that the third department's going to back them up on that. But this case doesn't appear to follow that approach. Do you think it has any real precedential value or no?
Unfortunately, no. As with Gronica, every time the board finds a hole in its procedures that leads to a reversal, they plug the hole. The only thing that really didn't get plugged was the ruling last year about brief lengths. Not that I've seen anyway, but I also think that practitioners are unwilling to challenge the rule, even though in that one instance it was challenged and thrown out. I think everyone is still sort of following those brief length requirements, even though they don't really have to. Nobody wants to have to go to the third department to prove a point if you don't have to. I also tend to like the shorter briefs because I think it focuses attorneys on brevity and conciseness, which is typically how you win before a judge in the board panel. Make it obvious what's wrong or what should be found, and then go from there. Moving on, another 300.13. This is a general exception rule. It's been settled for quite a long time that the board wanted specific exceptions. They wanted you to say, please note my exception to the court's finding of awards, or to the court's finding of further cause-related disability, or to a finding of accident, etc. A general exception is a term of art used to describe what is noted as, like a judge makes adverse rulings, the opposing party says, note my exception. In DiMaggio, that's what happened, and the board said that's a general exception. You failed to preserve it under B4B, which is the provision of 300.13 that says you have to make a specific exception at the hearing. The third department said, nope. They said that the board is obligated to look at the circumstances of the case and of the hearing itself. And that in this case, an adverse ruling was rendered, an exception was noted immediately after, and from the circumstances of those proceedings, it is abundantly clear which ruling and that an exception was being noted to the ruling being made, that is sufficiently specific, and they reverse. However, at the same time that they made the DiMaggio ruling, in a file I was handling, the board found an almost identical circumstance, a general exception. They found that that was sufficiently specific because it came immediately after the ruling. So one panel says one thing, another panel says another thing. The third department says, well, that's not too general, it's sufficiently specific, grant review. I mean, it's intriguing to me. The third department is a typical New York court where law office error or any number of other things are commonly accepted as grounds for defects in appeals or potentially even untimely appeals. The courts are typically liberal when excusing errors on the part of a party, particularly with response to appellate practice. We're going to see later on, there was an error in appellate practice before the third department in a comp appeal, and they excused it. And rather than denying review or spanking the party, they simply noted in a footnote that in future, do it the right way, and explained what it was. It's really disappointing. You could practice before the third department of the Court of Appeals, and you know, no one wants to, but you could accidentally trip over some kind of practice error, and those courts are not going to rake you over the coals for it. The board will. 300.14, changing condition. The Gallagher case stands for the proposition that a doctor can't just say a claimant has permanency. A doctor can't just say a claimant has more permanency or new permanency. It stands for the proposition that the board and the court must examine in more detail the underlying medical records to determine if in fact the claimant's condition has changed. If their findings are worse, they have worse range of motion, they have increased reports of pain, they have less function, they have neurologic compromise that didn't previously exist. This is a case that would infuriate anyone that saw it from our side of the board or our side of the bar, which is the parties stipulated to a whole bunch of permanency on this case. And among those stipulations was a finding that the claimant had no permanency to the hand. But in exchange, the claimant got a whole bunch of schedules to like an elbow and a shoulder. Later, the claimant's doctor produces a schedule opinion for the hand, which he had now already scheduled or conceded by stipulation he didn't have permanency to. So apparently with a straight face, but incredibly disingenuously, claimant's attorney pushes for a new schedule for the hand, despite the premise, the fact that they had stipulated to this no schedule finding. And the judge awards it. The board below denies the reopening request, says that it wasn't appropriate. The board affirms, or the third department affirms the board and says, yeah, even though there's this 30% schedule opinion, that opinion might be new, but the medical records underlying it indicate nothing new or different from the time that the claimant stipulated to a 30% to no schedule. There's no grounds to reopen this claim. There is no change in condition. So our note on this, it can't be expressed, a change in condition can't be expressed by merely a medical opinion on permanency. There must be a change in physical findings. You have to examine the case carefully. Don't just rely on claimant's attorney saying, well, we've got a schedule now and we didn't have one before. That's not good enough. Navarro v. General Motors. This case discusses standards of review. It is well settled that an interlocutory ruling of the board will not be subjected to review by the appellate division. They do not conduct what they call, in quotes, piecemeal review of a case. However, this decision generates what I call a separability conflict. A decision was rendered by the board that made several final determinations, but also remitted several issues back to the presiding judge to develop the record. The issues that were finally decided were appealed to the third department. The majority in this case looked at the decision and said, yes, while several of these rulings are final, other rulings that were made within the four corners of this decision are non-final insofar as they were remitted. They then concluded that because some of the rulings that were within the four corners of the decision were non-final, the entire decision was non-final, and thus they would not conduct review because the decision is interlocutory. Mind blown. Half the time, we can't even figure out what the board is going to consider interlocutory or not, because they quite often conduct a review of things that should be interlocutory. In fact, in my opinion, the only thing that is well settled as interlocutory is a finding of sufficient medical or prima facie, right? We know that that's interlocutory. The board is consistently denying those appeals. So you can skip that appeal and know that the issue is preserved if you need to appeal that once you get a determination on the compensability of the claim. But otherwise, the finality of rulings is just simply not an analysis often undertaken by the board. The dissent in this case from Justice Lynch, who has over the last several years written quite a few of the workers' compensation appeals coming out of the third department, is strong. He says, I don't understand what you're talking about. We constantly review decisions from the board where we rule on the issues that are final and don't rule on the issues that aren't, because typically our appellants don't seek an appeal from those findings. In fact, you do not need to seek an appeal from each and every finding made in a single board decision. You only need to appeal from some of them. I mean, it's a quite common finding from the panel or from the third department where they'll say, yeah, while the decision below rendered rulings on A, B, and C, insofar as the appellant makes no arguments on B and C, we deem any appeal from those rulings to be abandoned and are only going to proceed on issue A. You could go through and probably find a dozen cases in the last 24 months decided by the third department where the underlying decision from which the appeal was taken contained what under this decision would be a non-final ruling, and thus rendered the whole thing non-final. I don't get it. There was a back and forth too, because the majority opinion has a footnote attacking Justice Lynch. Justice Lynch carries footnotes, basically the whole decision is attacking the majority about whether each ruling is separable, thus rendering it justiciable, or whether it's not. This is going to have to be reviewed at a higher court, or we're going to have to get some clarification on this, because with the dissent, I think this throws a lot of appellate practice before the third department into question. Consider how much it costs to go to the third department. You know, you might be talking $6,000, $7,000, $8,000, $9,000 if the record's huge. Taking a decision to the third department for an appeal, and you can't be certain whether the separability doctrine is now going to be invoked, and whether the fact that some findings might be interlocutory could render the whole thing moot is just mind-blowing. Sufficiency of evidence. There's always a couple of cases from the third department on sufficiency. Turner falls into that. However, Turner is important because Turner sits on the shoulders of a case that came down last year that got our side of the bar in our office pretty excited, which was the Fox v. Altmar Parish case. Fox signaled an intent by the third department to look more closely at the quality of the medical opinions that the board was relying upon. It's a well-settled principle that medical opinions that constitute speculation or mere expressions of probability are insufficient. Fox clarified that the board shouldn't just look for some obvious expressions of probability or obvious speculation. The board needs to really examine carefully the opinion and its foundations to determine whether it's speculative or not. In Fox last year, the board was reversed by the third department, and the third department said, listen, these medical opinions that you're relying on are from doctors who don't have a good history of accident, who don't know about prior treatment and never looked at the records, and who are largely unaware that the claimant may in fact have a pre-existing condition. Those three failures render almost any opinion that doctor offers pretty speculative, and we don't think you should rely on it. Turner signals the board getting that message. The claimant in Turner had an established PPD claim, lifetime claim. He has a heart attack and dies, and a subsequent claim is filed alleging that the death is causally related to his established PPD, because essentially because he had a PPD, he sat around and got fat, he got hypertension, and his doctor says because he got fat, because he got hypertension, he had a heart attack and died, and it's due at least in part to his established PPD. When testimony was taken, the doctor who certified that opinion conceded he had never seen the hospital records from the claimant's hospitalization immediately before his death, and he'd never seen any of the claimant's PCP records that had for years documented the claimant's obesity and had documented the claimant's hypertension. The board says that's a speculative opinion, and we're denying this claim. On appeal, claimant's counsel not only argues that the board was wrong in rejecting the opinion, they also argue that 21 presumptions should have pushed them over the top. And the third department rejected that out of hand. They said, listen, 21 presumption says if it's an unwitnessed or unexplained accident, you might get a presumption. And in this case, this claimant died in the hospital. It was an observed death. So it was not unwitnessed, and it was not unexplained, because we have a death certificate that says he died of hypertension, a coronary event. He had a heart attack. And we have medical records that say he suffered from morbid obesity and hypertension. His death is explained. The fact that you're unable to make anything better than a speculative link out of the hypertension and the obesity to his comp claim is your problem. So Turner is a good sign. We have to look more carefully at the evidence. If a medical opinion is based on an assumption, your counsel should be A, rooting out that assumption when they're analyzing the case, and B, going after the doctor on that in cross-examination. Doctors should be forced to concede what assumptions they've made in their analysis, and they should be forced to admit what they don't know about a claim. Zielski. Oh boy. So I included this because there's one attorney that works at this firm that I just can't stand. Nevertheless, it's a practice point that we should all be aware of. It's about attorney's fees. Typically, we don't care about attorney's fees because it's a net zero for us, except for the fact that we don't want to encourage claimants' attorneys to be getting rich off of doing no work or collecting $500 a week rates, which you'll see some of the other counsel fee cases that we're not talking about today nevertheless did. In this case, claimant's attorney files a memo of law asking for the judge to make a ruling in their favor and says, if you rule in my favor, I want you to withhold a $52,000 fee. All right, my mind is already blown because I just can't imagine any case ever in workers' comp where $52,000 worth of attorney time was put in on that claim, even over its entire lifetime. Absolutely nuts. The memo of law is submitted. The judge rules in favor of the claimant, but denies the attorney fee request and says, because you requested the fee in the memo of law, but didn't accompany it with an OC 400.1, a fee application, your request is defective. I'm going to award you the maximum fee absent an application, which is $1,000. $52,000 reduced to $1,000. That's harsh. Goes to the board panel affirms. Appeal to the third department. Okay, there's a lot of money involved. I get it. Appeal to the third department. This was the case that I referenced earlier about errors in practice. The third department, in deciding Zielski, said, A, we're not going to, the board's application of the statute is right. If you wanted the fee, you needed to put an application before the board was going to rule on the fee. You asked them to rule on a fee. This whole thing about please withhold a fee pending an application thing, that's no good. That only works if the judge is going to let you do that. Otherwise, you're out of luck. But they tell the attorney in this case, you should not have filed this application in the name of the claimant. An appeal that is solely on attorney's fees should be filed in the name of counsel. They said it in a footnote. They said it politely. Even though this shows up as Zielski, which is the name of the claimant, it should not. This should be Connors and Ferris versus New York State Workers' Compensation Board and others respondents, right? Because, the Department of Corrections, they may have cared about this because I'm sure that the request had something to do with reimbursement going to the employee or to the employer from the employee. But otherwise, they're not going to care because it just reduces the claimant's award. So there you go. If the third department can be professional and forgiving about a major error, such as filing in the name of the wrong darn party, well, sheesh. Why are we practicing in a pit of vipers? Oh, well. If wishes were horses. Labor market attachment. Don't read this. Just let me tell you the story. And please don't infer anything about politics from this. It's simply a matter of case law. It is well established that a injured worker's legality as a resident of the United States is irrelevant to their receipt of workers' compensation benefits, with one exception. Under Section 15.3b of the Workers' Compensation Law, a claimant must undergo evaluation by board or state vocational rehabilitation counselors in order to qualify for benefits under 15.3b. The Third Department ruled many years ago, I can't remember the exact date, that an illegal alien cannot obtain benefits because they cannot participate in that program, because that program requires you to be a citizen of the United States and of the state of New York to cooperate, to participate in it. That's the law. In this case, a claimant was attempting to reattach to the labor market and apparently did a pretty shoddy job and couldn't avail himself of all sorts of opportunities to attach, like board retraining, voc rehab, because of his illegal status. You know, he simply couldn't get into the programs. So he did a pretty shoddy job search. The board rejected the shoddy job search and said, listen, we understand that the claimant can't do this stuff because he's an illegal alien, but we're not going to hold this claimant to a lesser standard than a citizen. That would be unfair. The Third Department reversed and said, we don't buy it. The board didn't make a finding that the claimant didn't avail himself of those things. They just simply didn't talk about it in great detail, and they said that he couldn't do it. We find that the claimant's job search was sufficiently detailed, despite the board's findings to the contrary, that the board should have found him attached. This is strange policy making. There was a dissent in this case from one of the more liberal justices, Justice Mulvey, took issue with the decision and said the majority didn't hold the claimant to his burden, and the majority's opinion makes a different standard for claimants who are attempting to attach, whether they are illegal, they're illegal immigrants or citizens of the state of New York and the United States. This claimant got a pass, and the Justice Mulvey's dissent attacks it. I mean, our review of this basically was this claimant, he did the best he could by walking through New York City neighborhoods a few days a week and asking employers if they had a job for him, whether or not he could do it, whether or not they had one. Justice Mulvey felt that it was not the Third Department's place to reach a conclusion about the merits of the claimant's job search different from the board's, absent some obvious finding otherwise. The majority did not. This is a strangely disconcerting case. It appears that there's some kind of significant rift at the Third Department about this, and it strikes me as potentially what it really is that the political opinions of the justices deciding the case showing through, whereas the court's own precedent says they can't use the claimant's illegal status to provide them with any sort of lower standard, and that unfortunately, because this person is illegal, they can't participate in certain programs, is so beyond the scope of the court's review and authority that they can't do anything about it, except here they did. So I don't understand. You know, like I said, setting aside political views, this is a significant change in the court's analysis, and it's disturbing for that point. Fees out of reimbursement. What was thought to be a well-settled matter, you know, occasionally there are hiccups in the law. The NYSEF seemed to have blazed the trail on this, that made it clear that if a reimbursement was being directed and an attorney's fee was being directed at the same time, the fee had to first come out of the money moving to the claimant, and only if that money was insufficient, then you would tap into the reimbursement. And the purpose of that rule was to not provide the claimant a windfall, because that claimant would receive both the wages paid during their absence, and then they would receive the comp payments. And if there was any diminution due to the fee, it would be eaten by the employer, which is just entirely disproportionate, extremely unfair, and it's against public policy because it discourages employers from paying wages during periods of absence, which is an express and explicit intent of the law. The workers' compensation law in the legislature encourages that and wants employers to do that. In both Enoch and Renazzo, the board had sort of cleaned up some discrepancies in its case law and found that basically when you're awarding a fee against an award that may have reimbursement moving to the employer, the fee must first be taken out of the money moving to the claimant, regardless of prior fees, regardless of prior reimbursement. The money has to first come out of the fee has to first come out of the money to the claimant. So hopefully settled and will remain so. I take a deep breath. Green v. Dutchess County, quite possibly the worst decision I've seen in a long time. One of several decisions that came out from the third department that struck me, and as you guys know me, I have a high opinion of my own intellectual abilities. This opinion reads as though it is very self-satisfied with how cute and academically smart it is and that they understand the statute. Yet, they reach a ruling that absolutely boggles the minds of every practitioner except for the wackadoo that brought this decision up. The finding in Green v. Dutchess County is, if a claimant who is classified with a capped PPD dies for reasons unrelated to the claim, Section 15 sub 4 provides that the remaining balance of the caps should be paid over to the estate of the claimant. All right, I know you guys are all muted, but everyone should just be screaming obscenities at the screen right now, right? I was when I read this. This makes no sense. The court's analysis is that because Section 15.4, which does provide for the payover of an award, of a remaining award to a decedent's estate, doesn't distinguish between capped and uncapped benefits, or capped benefits and schedule loss of use awards, they're going to apply the same analysis that they have used to allow posthumous schedules to be paid. That said, they acknowledge that part of that analysis that makes it okay to do that with respect to schedules is because a schedule award is not allocable to any particular period of time. But a PPD award is, for God's sake. You're out of work, you're disabled, and for that week you get paid a cap, right? And then we take 1 week off your cap. If you're dead, you are decidedly out of work for reasons unrelated to the case. Your future loss of wages is it's de facto unrelated to your disability. Because guess what? Your disability's gone. This is the perfect example of a superseding disability. You know, the argument against a superseding disability is, well, the claimant didn't simply stop being disabled by the comp case because they had a subsequent injury. Well, when you die, you absolutely do. You stop being disabled because you're dead. It also overlooks the Court of Appeals finding in Burns v. Variali, which said very clearly that you couldn't reduce a permanent partial disability award to a sum certain, and in later cases, even a capped one to a sum certain, because there are any number of reasons, labor market attachment and death chief among them, that a person's entitlement to benefits could cease, right? That's why we pay as we go under Section 29 when we're contributing to attorney's fees. Too smart by half. You know what's most sad? If you look at the top of the screen, motion for leave to appeal was denied. So I don't know what we're going to do about this. I pray, David Wertheim, if you're listening to this, I pray to the gods of comp, all you geeks out there. I hope that the board takes the position that while this may be good law, that there are ample ways to prevent it from happening, such as finding that the claimant's divested of any rights by death as a result of causal relationship. I just don't see it. Plus, this case makes no distinction between capped and uncapped claims. What do we do for the uncapped claim? What do we do for the uncapped claim where the claimant has already exceeded their life expectancy under the tables? Does the estate pay the comp carrier back? I don't think so. It's nuts. Hard, bad beat. Terrible, terrible case. Arias, another case where I hang my head low. We probably all remember where we were when the board announced that matter of Tahar had come down, where the third department knocked that case out and said, all those claimants that have mixed permanency cases, schedule and non-schedule, they get whichever award is available to them. If they're working, they get the schedule. If they're not working, they get the PPD, because they decided that they knew better, and that because the statute says award, makes no reference to classification, that they were available because the court doesn't want to treat disparate groups differently. Why should the working claimant be denied an award and the non-working claimant immediately benefit from it? What are you talking about? It's a net zero proposition, appellate division. If they're working, they're getting wages. The purpose of this system isn't to treat people equally. It's to get people recovered and back to work, or provide them with some sort of award that compensates them for loss of earnings. It might be an ameliorative statute, but it's not designed as, like, I don't know, some sort of communist social welfare tool. So Arias, the board had ignored Tahar and said to the third department in its decisions that they thought it was wrong. In Arias, the third department said, nope, sorry, follow our rules. That's what we said, make the award. Terrible. The only thing that the board did get the third department to uphold delaying, but not denying, the award of the schedule outright. Fernandez, the board can delay the making of a schedule award until all sites have permanency evidence. The same is true in Saputo. Cosides is the great tidal wave of old cases. All of you who have old closed claims in your book of business probably have several that closed on a PPD finding where there had been evidence of a schedule, but you avoided the schedule because the claimant was classified and was working. Cosides is the reopening of those claims and claimants counsel looking for and obtaining the award. So it's happening. It's probably going to happen a lot. You know, guys like Alex Dell who hunt through their old files are going to go back and find all those claims and reopen every last one of them. The governor wants to keep the costs down for employers. Something's going to have to be done about this. And Green. Hale, we talked about changing condition having to be established by medical evidence. This is another case that falls under that same category, except we separated it out because it raises a really unique point. Weeks of protracted healing are not a permanency award. I mean, they're not contained in the statute as a permanency award. They are an adjunct and flow from a permanency award, but they're not a permanency award in themselves. This is an interesting case. Claimant has an injury, doesn't undergo surgery, continues working, is awarded a schedule, then proceeds to have causally related surgeries. The first SLU did have a PHP award. The claimant, after 2 subsequent surgeries, has additional TT time, so there's more PHP on the file. But there's already a schedule in place. The carrier defends the file smartly by saying, well, you have temporary total, that you can't just add that to your PHP total. The only way you get to that is if you rescind the schedule and re-award a new schedule. And even though you had surgery, that surgery actually improved your condition. You have no change in condition. Your condition didn't get worse. You cannot reopen the file to add the PHP to it. The board and the third department agreed. They said, PHP is, quote, simply an incident of the schedule award, which is neither a classification nor a disability in itself. And the medical evidence in the file does not demonstrate any change in the claimant's medical condition. The claimant's condition is no worse because of the surgery. You don't have grounds to reopen it. And in a couple cases, we're going to talk about Robinson. And the Robinson case, again, it sort of demonstrates a little bit of the naivete of the third department, but this way it helps us, which is surgeries are intended to improve people. Now, if you practice a lot in comp, you know that most of the time people have surgery, and despite the fact that they might actually in private and never admit to it, do way better after the surgery, they all have permanency. No one is actually better from their surgeries, right? Or very few people are. The third department says the premise of surgery is to make you better. Simply having surgery is not a change in condition. We'll talk about that in a little Sanchez v. Jacoby, another ridiculous decision that is enamored with its own sort of intellectual complexity. The board had found that once you were classified and operating under the caps, if you had a post-operative TTD benefits, you couldn't get them. All you could do is get your PPD award, that the permanency was not automatically rescinded because of the happening of a surgery, and that they would consider reclassification if and when you demonstrated a change in condition, because the board was taking the position having post-PPD surgery simply means that you're looking to improve your condition. There's no reason to suspect that you're going to be made worse from it. And the third department, their decision relies on section 123. They said, well, listen, and they misused the phrase classification. It's a term of art in comp. They shouldn't be allowed to use it. They're not comp lawyers. They don't know how to use it. They misuse it in this case a lot. They basically say the board should use its continuing jurisdiction under section 123, which is an absurd catch-all, right, to temporarily reclassify the claimant from the PPD to TTD. And because they didn't choose to do so here, they failed to follow the statute. I'm at a loss. Nevertheless, Sanchez didn't address two subsequent questions, which is, are temporary partial benefits permitted here? And then what happens if you can't reclassify the person? All the third department said was that the board should toll the caps during the period of temporary total disability. That you have to rely on a catch-all should convince the justice writing the opinion that it's probably not great rationale. Sadness, serious sadness. Here's the Robinson case. Stands for the proposition that just because you had surgery doesn't mean you get to reopen your claim and allege a change in condition. You'd better have medical that shows that you're worse off. That's the premise of this claim. So don't just assume that because there's surgery, they're worse. Claimants' attorneys love to do that because they want to reopen every claim for whatever reason they can. Get some money moving, get some fees. Schedules. This is a troubling case that I want to talk about only because it is it rejects in part potentially a commonly made argument. That argument being that because portions of the claimant's disability or permanent disability are not specifically enumerated under the guidelines, they are therefore not entitled to points for them. We've probably all had a claim where a treating doctor said, this claimant has this particular injury that I cannot find reference to in the guideline. But that injury is very similar to another one that I do find reference to in the guideline. And because it's similar, I choose to award percentages consistent with that similar condition for this one. This rejects that argument, at least in part. The only distinction is in this case, the board said no permanency. The injury was a hamstring tear. It's a torn muscle. The argument from carrier and employer below, which was accepted by the judge and the board, was hamstring injuries aren't covered, doesn't allow for permanency, no schedule. Claimant takes an appeal and says the guidelines actually explicitly say in its general provisions that they are designed to provide an award for injuries, including injuries to muscles, tendons, and ligaments. Just because muscles, tendons, and ligaments of the leg may not be specifically mentioned doesn't mean that the permanent impairment suffered by this injured worker is not addressed by the guidelines and thus for no impairment is permitted. The problem is that the case is also bad. So it's bad facts make bad law, right? The board's not reducing the schedule, they're rejecting it altogether, right? This guy can't get any permanency, so that's bad for the result. But it's also bad because the claimant did have a permanent residual physical deficit. The hamstring injury caused a problem, and the IME conceded that, and the IME agreed that the claimant should get some kind of schedule, and actually agreed with the percentage by the treating doctor. So you got unanimous medical evidence of the type of schedule that should be awarded, and how the fact that the guidelines don't apply sort of isn't right. The legal issue is ruled against us. I really dislike this case, but it's distinguishable. Remember, when we're arguing, typically we're not arguing to deny award in its entirety. We're saying that because there are enumerated conditions to get points for, the schedule should be limited to those enumerated points, not to the unenumerated ones where the doctor's taken a guess. Terrible case. Hate it. Calabrese v. Fortini, another LOMAD case. We win. Third department affirms finding of the board. Claimant committed fraud. This guy showed up with labor market attachment materials, not knowing that we had a really thorough investigation report in hand that proved that he didn't make the applications, that the employer wasn't accepting applications or hadn't advertised for that job, that the employer didn't accept applications in the format which the claimant alleges to have given them, i.e. either saying that he delivered them in person or saying that he did them online. The employer said the opposite. Or the employer actively reviewed their records and found that while they had the position advertised, the claimant had not applied for it. This guy comes in and gives detailed testimony that he did all this stuff to look for work. We drop a huge investigator's report down on the table and say, BS, we're raising fraud. This was mandatory and discretionary penalty, lifetime ban for committing fraud. Appeal to the third department affirms. This guy lied through his teeth. He committed perjury. It is oftentimes an excellent investment. Even though investigating the validity of a job search might be expensive and time consuming, if you have reason to believe that a claim stinks, good practice point, it's worth the money to do it. T-bout is interesting only because the third department made a mistake. On January 2, they denied review, indicating that they thought the decision was interlocutory. They were not going to grant review. A rehearing request was immediately granted, and they reached the merits in this decision. I picked this too because this claimant was found guilty of fraud because she had represented that she did not have any pre-existing psychological conditions while pursuing a claim for consequential psychiatric conditions. The employer obtained evidence that the claimant had, and this is an exact quote, a very full plate of psychiatric conditions predating the accident. The IME examiner was given that information. That's the quote from the IME. If he had known that information before, he would have rejected the claim on causation instead of giving it. Fraud's found. Covington. This is Genduso. Last year, the Genduso decision came down, which was 2 years ago, was super great. It basically said, if you get a schedule for the shoulder, and then you have a new accident and you get a schedule for the elbow carrier can take credit for the shoulder schedule because the statute does not award schedules for shoulders or elbows, it awards schedules for the arm. Genduso was not taken up. However, a case this year was Johnson v. City of New York was granted leave to appeal to the third department or to the Court of Appeals. In each of the rulings that came before the third department, and there were many of them, the third department affirmed the board's ruling that credit for the prior schedule was proper, even if it resulted in a 0% moving on the case. They rejected all arguments to distinguish elbow versus shoulder or knee versus hip or whatever. They just said it doesn't matter that the prior schedule might have emanated from a different joint or the points might have emanated from a different provision of the guidelines. To avoid getting more than 100% schedule of any limb and to properly compensate for loss of use of that limb, you get the schedule. That's it. This is being challenged aggressively by the claimant's bar. So leave to appeal was granted in the Johnson case. Covington was another claim. Here's a couple more. Look at that. They are frantically challenging this holding. That the third department or that the Court of Appeals granted leave gives me pause because since Justice Pigott left, I have very little faith in what the Court of Appeals does with comp claims because they're even further removed from the practice. And the rulings that came out of an American economy were strange and didn't make sense either. But nevertheless, look at this. They are frantically attacking this because it's cutting off their biggest fee, which is taking fees on schedules. And it's making them angry because half the time their own claimants aren't telling them that they have prior schedules floating around out there. So this is causing huge problems with respect to the claimant's bar relation with their clients, because they're telling their client, you're going to get a $50,000 schedule, show up at the hearing, defense counsel says, Judge, can you look for prior schedules? The judge finds 3 of them, and all of a sudden the claimant walking away from the hearing without an award. I mean, I get it. I mean, let's hope this one holds up. Fingers crossed. If the attorney who's defending Johnson is out there, call me. Or if you know who it is, call me. I would love to help on that case. St. Albans, more apportionment files. We're talking about it today because it's one of the most commonly mistaken standards. The standard of apportionment to a pre-existing non-work-related condition is, in fact, whether the condition was symptomatic and disabling. The primary point, whether it was disabling, right? The claimant has to have been working under restrictions. With the exception of Scally. The Scally case says that if the pre-existing condition that is not work-related would have resulted in a schedule, you can obtain apportionment provided that you have sufficient medical evidence to determine what that schedule would have been. So in this case, the board thought that the carrier was trying to have their cake and eat it too. Unfortunately, and fortunately for the employer, the third department doesn't agree. Just because the employer controverted a claim and got it disallowed doesn't mean that they can't take credit for it on an apportionment theory invoking Scally. I don't know what the board's idea was here, but you know, just wasn't right. Excuse me. 2 more cases. I really liked the Garrett Chant case because the board starts to take a view that you have one claimant, you get one LWEC. It doesn't matter how many cases you have. It doesn't matter whether they're established for overlapping sites or not. You simply can't have more than one LWEC per claimant. And if you have more than one case with a non-scheduled permanent partial disability, you need to grab them all, gather them together, establish overall permanency, and apportion it between the claims. In Cody, they took that theory a step further as between 2 files that had overlapping sites, and they tried to use the Genduso type of apportionment and say, because the first case had a 70% LWEC, and the second case concludes that the claimant's LWEC overall is 75, we're going to let the second case take credit for the first 70 and only have a 5% causally related LWEC. The third department actually very thoughtfully noted that they understood where the board was coming from, that they were essentially, the board was trying to sort of standardize apportionment as between SLU and PPD claims and say, let's just do it all the same way. You know, like you get permanency in the old file, that's how we're going to do it. It was rejected, unfortunately, because the old claim in the Cody case was a pre-cap disability that did not include an LWEC analysis, whereas the second one was. So what's going to happen in Cody is they're going to have to go back, and they probably already have, or they're beginning to, go back and essentially obtain an overall apportionment opinion or overall permanency and then apportion it between the 2 claims. Let's skip ahead. We're going to skip that one because we're already at 53 after the hour. Love v. Village of Pleasantville is a great case. I talked about this 2 years ago. This was 2 years ago. This came before the court because the employer failed to timely file a pre-hearing conference statement and was found to have waived all defenses except causal relationship. It went back to the board, who found that because they waived everything but causation, and because there was a medical opinion saying that the claimant's motor vehicle accident led to his injuries, the case had to be established. The employer, very intelligently, great defense, says during this litigation underlying, no. Just because an accident leads to an injury does not in itself create causal relationship. Causal relationship is not the simple medical matter that you are trying to make it out to be, board. There are standards. An injury must be causally related to the employment. Causal relationship has a flavor of scope and course within it. that even though we're barred from arguing scope and course, the claimant nevertheless, as part of causal relationship, must establish that there's a nexus between the accident and the employment. This guy has serious gumption. He's a sheriff for a village on a personal trip back home from visiting his son at school for 3 days, and he's in a motor vehicle accident. His link to his employment is only two things. One, he's driving his official vehicle, which I don't even know how you do that. Typically, you're not allowed to do that. And two, he has his cell phone on him because even though he was on vacation, he could still be called. So his position was, even though I was driving for purely personal reasons, because I could possibly be called, I'm essentially always in the scope and course of my employment, which is absurd. I mean, that would work while he was sitting on the toilet on a Friday morning before he goes into work. I had my cell phone on me. I must be in the scope and course of my employment. The third department rejected the board's establishment of this case and said that the claimant had not established a nexus between his employment and that there was no degree of control exercised by the employer of the claimant's activities at the time of the accident. That is the causal nexus. The board, I can imagine, is going to be hopping mad because this is the type of thinking that defense attorneys make all the time, which is burden on the claimant, and it's more than just medical to establish causation. Don't just say because medical relates it that it's causally related. It is not purely a medical issue. It has legal components to it, and the claimant must satisfy those. And the claimant, telling the truth about what was going on, still couldn't convince the third department that this accident arose in the scope and course of his employment. It's under causal relationship. The third department describes it as a causal relationship decision, but that language about sufficient nexus and direction and control, that's pretty similar to scope and course analyses. So Love stands for the proposition that you may have waived all your defenses, but you can still raise a lot of them by channeling them through causal relationship. Good decision. I like this one. Hanley v. Trustees, another Fox v. Altmar Parish progeny case. Unanimous medical evidence of causation. However, there is a ton of testimony from lay witnesses from the employer that this claimant had never been exposed to or could not have been exposed to the chemicals she claimed to have been exposed to. Just couldn't happen. Claimant doesn't have any evidence apart from her own testimony saying she was exposed to those chemicals. Despite the unanimous medical evidence, the board rejects this claim and says the medicals from the doctors are premised upon faulty premises that the claimant suffered any exposure to chemicals at her employment. This claim was disallowed on only the lay witness testimony over the presence of unanimous medical evidence of causation. Cool case. Great for chemical exposure claims too, because the language in the recitation of the facts of the decision can be very guiding to how you might want to defend the claim and what sort of testimony is going to get you what you need. So if you're setting up defense on a chemical exposure case, look at the Hanley case. It will give you a nice roadmap. One of the things you might not want to do is get an IME unless you're very certain that your doctor is going to rule in your favor, find in your favor. Page is on here only because the Page case comes up again and again and again. This is a chemical sensitivity claim that the board finally realized after about 5 years was bullshit. And in 2012, they found no further causally related disability to the chemical sensitivity stuff. Then the claimant starts to try and amend the claim to include psych disorders, saying, even though I'm not disabled from it, it caused me to have psych disorders. It's amended for the psych disorders. It's been to the appellate division third time. The board panel keeps trying to cut off this lady's benefits. The judge can't stand this lady and makes findings against her because they don't buy what she's trying to sell. The third department reversed it this time and said, we're just not satisfied that you've properly documented your findings here. If you want to deny this claim, you got to do better and you got to address certain holes in it. It's here just because it's the gift that keeps on giving. This claim keeps coming up. There's a famous special funds case that came up on, it stopped recently, but it came up 4 or 5 times. 15.8D reimbursement, only to say If you only have a concession in the file and 15.8D hasn't been established, you're done. You're sunk. Conveniently, once the board took over responsibility for administering the special funds, they started making rulings that the concessions were not binding, even though for a while they found that they were. And the third department has affirmed everything. Latches doesn't apply because it's not a real stipulation. You may have reasonably relied on it to your detriment, but apparently their opinion is that's your own fault because you knew what the standards were. You should have put that stuff in the file. I don't know what to tell you. Terrible. Scope and course of employment. My title here is sort of funny because this is one of those instances, and it occurs every attorney and every practitioner, even if you're, claims examiner, or no matter what you do in the system, you will occasionally get a decision, whether it rules in your favor or not, that is premised upon an analysis that you never considered or never argued, and that's this case. Wright v. Nelson. There are some guys, I don't even know how this works financially to the benefit of the employer, but this employer brings a bunch of guys from way upstate, like Canadian border upstate, down to Westchester County to do some tree removal work. And because the drive is so far, they put all these guys up in a hotel. So they're staying at a hotel, and then they get in their work trucks and they drive to a specific location. And from there, they get on their equipment and go out to the jobs. The judge, the accident, by the way, is motor vehicle accident going from the hotel to the fixed work location where they start work every morning. The judge says, this is a mixed case. You're a fixed location employee. You're portal to portal until you get to that fixed location. So your motor vehicle accident from the hotel to the fixed location is not within the scope and course of your employment. The board reverses and says, because the employer is paying for the hotel, we're going to treat these workers like they're at a work conference. They're always within the scope and course of their employment because staying at the hotel inures benefit to the employer, and they're not traveling from their home. They're traveling from a hotel provided by the employer. So third department affirms. They're okay with that. The traveling employee exception is what that's called. I call it the conference exception because that's the most easily illustrative. Like when you go on a work conference, you're covered, from the time that you, leave your home to get on the plane to fly to New York City, all the way through your hotel room, whether you're at dinner with clients, you're basically covered until you get back home. So deep thoughts from the board. Caprero be a matrix absence management. My home, my workplace. This is going to be a big deal. This injured worker was hired to work from home. He was injured on a work break, moving furniture into his home, which he claimed he was buying on his own. It wasn't authorized or paid for by his employer, but to help him work from home. The board denied this and said that basically he was not doing a work task at the time. And because he's working at home and he's not doing a work task, this rises outside the scope and course of his employment. The third department reversed and said that there is no basis in law to not apply the brief interruption in employment rule to somebody working at home. Just because they're at home, there's no distinction. Well, there's an obvious distinction. We should not be insurers of individuals who are within their own homes. Hell, they aren't even insuring themselves in their own homes because their homeowner's insurance excludes them. So does their renter's insurance. So I don't know. There's no evidence that this was appealed up. There's no evidence yet what the board's going to be doing with it. And there's no evidence about whether or not, in my opinion, this could be solved easily by the legislature in 2 lines. By saying that if an accident doesn't arise directly as a result of a work activity, it's not compensable. We don't control whether somebody sleeps on the 2nd floor but works in the basement and therefore has to ascend and descend 2 flights of stairs, and we're responsible for their knee injury. Like, that's absurd.
James, I've got a question on this case. So it's apparent that this decision could have sweeping implications in a post-COVID world. First, do you believe that COVID played a role in the court's decision here? Because it was decided in October, and seeing as COVID will likely lead to many employers choosing to stay in a regular pattern of work from home even after the current restrictions are relaxed. Is this it as far as a work from home standard goes, or do you believe there will be a COVID variation?
I think, I don't believe COVID had anything to do with this, because if it was decided October 2020, that means that it was probably perfected in sometime in the summer. I can't imagine that the ruling came out during the pandemic, the underlying ruling. In fact, I know it didn't, because I remember when Board's General Counsel discussed this case, it was well before the pandemic. I think it's distinguishable. The facts of the Caprero case was the claimant was hired to work from home permanently. Lots of us are working from home by order of the governor, not by our employer's choice. So I believe that there are grounds to distinguish it. I also believe that it is very possible that the board could take this case back and still deny it, because they could find that it's a purely personal pursuit, and they could also find that the deviation in employment was not sufficiently brief to fall within the exceptions. You know, moving furniture into your house is not like a 5-minute smoke break. That's the third department said you should have imposed the smoke break rule. It was a brief deviation in employment. And even brief deviations for employment are compensable, even if they're purely personal. But if it's a lengthier deviation from employment, it has to be for purely personal purposes. And the claimant here testified that he was bringing in a desk to help him work. Because the employee says that it was related to his work, does that mean that it is work related? I don't know. The employer was pretty adamant that they didn't authorize this desk, they didn't provide it, they didn't need it. It was for his own, it was for the claimant's own benefit to like work at this particular workstation. I think this is going to have far-reaching consequences. I think there are some employers who are not going to want their people to work from home because they're not going to want to be insurers of people within their own home. I mean, the natural outlay from this is for an employer to tell an employee in a work from home agreement that because we have to insure you basically as a comp carrier, or we have to insure you within your own home, we're going to require you to put up grab bars in your bathroom. And we're going to require you to do nothing other than work. And we're going to require you to have your webcam on at all times so that we can look at you when we want to. And we're going to keystroke monitor you. I mean, it's ridiculous. This claim should have never been made, but it was. And now we have this terrible law. I hope the board figures out a way to narrow the scope of this ruling. Oh, by the way, we are slightly over time. Does anyone have any objection to that I keep going? We're almost done. All right, hearing no objection.
I had a quick question on that.
Yes, Robert.
Yep, it's Robert Hamilton. So I just had a question. So I listened to the explanation on that about the employee bringing the desk into his house to, help him with work or whatever he needed during that day. Now, what would be the difference between that if I was walking into the law firm and I wanted to bring in one of those stand-up desks, something that I bought on my own? I enter the law firm and I slip and fall. Now, I'm still in the course of my employment. I'm still at work, but I'm doing that for my own personal gain. Wouldn't that be a similar situation?
So all the facts are the same, except you're now carrying the desk into your employer's place of business. I think that's the primary change here, and that's the fact that the board tried to distinguish, which was that the employee was in his own home. And there is a natural concern of all employers who employ people who work from home about what they're doing at any given moment and whether they're liable for it, right? I mean, I would think about it this way. The distinction that I draw is because you are at home, I cannot exercise the same direction and control over you as I can if you're in my office under my eyes. And I'm also not able to ensure the safety of the workplace because I don't own it or control it. So that's the distinction that I think the board was really upset about, was that, like, how can you make the comp carrier an insurer of a homeowner in their own home for an activity that doesn't necessarily have much to do directly with the nature of the employment? I mean, the question I asked sort of rhetorically, Robert, is what about the employee who completes a task, gets up, grabs the tea kettle that they have on the stove that they put on a few minutes ago, pours themselves a cup of tea, and burns their hand badly in their own kitchen? Who's paying for that? If it happens at work, that's a brief deviation in employment. That might be a comp claim. But because they're in their own kitchen, who feels comfortable paying for it? I don't know. I would really not want to. Because I might have told that person, you're not allowed to have hot beverages, because maybe they spill stuff all over themselves. I don't know. But, you know, it's frustrating. Latches everywhere. I'm only discussing this to remind everyone that, of course, their equitable relief is available in workers' compensation claims, but it is only available with respect to issues that are not purely legal, which is a standard that wasn't discussed in the Jones case, which I thought they would have brought up. And the third department will go out of its way to disagree whether delay was reasonable or unreasonable, which is what happened here. A 20-year delay in raising or pursuing concurrent employment is deemed not unreasonable because poor claimant's counsel fired him. I found this interesting because the court went out of its way to reverse the board and disagree about whether the delay was unreasonable and whether it was well explained. DeLuca. This is a great litigation practice case. The claimant argued that the carrier should not have been allowed to seek and obtain a finding of preclusion of their medical reports because their doctors refused to comply with subpoenas for testimony. They argued that instead, the employer was required to subpoena and enforce the subpoenas. The third department reminded the claimant's bar in this case, and I hope they read it very carefully, that the obligation for producing a witness in support of the case rests with the party relying on their evidence. So while the carrier might have been directed to subpoena the witness, they were under no obligation to force them to comply with it. And right now, in the era of COVID, where you can't get a court hearing for anything, I don't know how the board could properly do that. They'd be directing you back to a court to which you cannot avail yourself of any relief because they're closed. So good litigation practice. I get a lot of angry phone calls from New York City lawyers who don't want to bother scheduling testimony. They don't even want to provide conference lines. I mean, it's kind of childish and absurd, but whatever. Gimber, just a reminder, contracture in an occupational disease claim. Section 44 apportionment does not just apply because the claimant's prior employment was the same as his current employment. Or it doesn't just apply because there might be evidence of exposure to a disease vector in the prior employment. Contracture requires medical evidence establishing that the disease process began or started at a certain point. And it can't just be an opinion of a doctor that doesn't have an underlying medical record. This is a meso case. The record is replete with information saying the latency for asbestos exposure is 40 plus years. The claimant's employment before Eastman Kodak exposed him to asbestos, therefore it contributed to his mesothelioma. Board says that's not enough, third department agrees. Contracture, you can't just assume contracture, and therefore you cannot just assume the applicability of section 44 to a claim. Section 28. There are tons of claims out there that exist as an ECF simply because the employer or the carrier filed a C2F, right? That does not count for the claimant's burden unless there is clear evidence establishing a complete claim, e.g. enough evidence for the board to have either establish it by an amended or an administrative decision or to bring it on for a pre-hearing conference. The claimant has to be the one to file it. Only if filings made by other parties are sufficiently clear to establish that a claim with an injury and a disability has taken place and is the statute told. This claimant tried to rely simply on the C2F, and the board said, no, you didn't timely file this claim, even though the C2F has been in there for years, and that we assembled a file years ago. They said because the C2F and the notice of assembly indicated that it was only a sprain injury, none of the other parties to this claim had any indication that this was actually a case where an injury took place, particularly one that was going to result in any permanency. I mean, some sprain injuries don't even rise to the level of reportable under Section 110, right? You could sprain your ankle at work, not require anything more than first aid, and be back to work the next day. That's not even reportable. So just a good reminder, don't give up. Don't give up timely claim filing just because there appears to be a document in there closer in time to the filing. And that's it. We only went 16 minutes over. We covered everything. Let me see. I'd like to try and unmute everyone. I'm not sure that I can do that. Naji, can you take over and unmute everyone, and then we can open it up for questions?
Yes, give me one moment.
Thank you. I have a comment from Tom Dickinson. I represented the special funds group at a hearing and had to argue that a 15.8D concession that I myself signed was not a valid stipulation. And he says, I guess I was right. Good for you. That's awesome.
Okay, everyone is unmuted.
Okay, I got a comment from Rachel Egan. If you're in your home, there will never be a witness. How would we fight these claims? I guess we're going to subpoena husbands, wives, children, security cameras from inside the house. I don't know. I don't know. And then let's see. Ray Seligman to everyone. Purely fact-based analysis that the ALJ will either believe the claimant or not. I guess that might be true.
James.
Do we have any questions?
James.
Yes.
What if you work with your significant other from home and you are both employed at the same employer? As I am.
Then I would deny both of your claims.
I have previously disclosed that I have on the walls of my office what if I were to bump into one of them and spear myself or something?
Listen, if you are injured as a result of a fixture of your own premises, I'm going to deny that claim.
I respect your position.
Yeah. For the same reason that I laid out right there earlier, is that I can't control how safe your home is. What if you decide to work from one of those, you know, those fancy chairs that you hang from the ceiling, those like egg leaf chairs or whatever?
Oh, stop.
So what if you decide that you're going to sit in that cross-legged with your laptop on your desk, right? Because it's comfy. But all of a sudden the chair, because you installed it improperly, releases from its mount and you land on the ground and hurt yourself. And even worse, you break the computer that I gave you. Like, I'm teasing about that. I'd be more upset that you were hurt rather than you broke the computer. But I mean, how can that, you might have been doing work, but I mean, what does that have to do with it? What does that have to do with your work? Nothing. Mm-hmm. I think that's the distinction that the board's decision was trying to make, is like, if you're trying to do something unique by working from home, that you could not have accomplished at your workplace, you can't turn around and try and claim benefits for it or claim scope and course. Because, I mean, I'll ask you this question. You don't have to answer it. But if anyone who's working from home, do you want to be subject to the type of scrutiny, restrictions, and supervision that would be required to make an employer comfortable with that kind of coverage? I don't think so. Do you want your employer knowing every time you get up to go make yourself toast in the morning, or every time you get up and you're emptying your dishwasher?
The scenario you previously described of having my webcam on at all times or having grab bars by the toilet, everyone should have them anyway. You might have a disabled friend over, but no, I would not like that scenario at all, even though I'm doing this temporarily.
Right. Nobody wants that, but that's what the courts are going to force if they don't get that squared away. If they don't narrow the standard for scope and course within your home. Because employers' reactions are ultimately going to be, yes, if they're forced to allow the work from home, what they'll do is they'll just deny it. They'll say you have to work in an office now, which, you know, that might not be what the employee wants. Or they're going to say, yeah, we're going to take extraordinary measures. And if you're unwilling to have your webcam on and for us to listen to you and see you while you're working at all times, then you can't work for us, you can't work from home. And this is an at-will state. So people are going to have choices to make, and employers will have choices to make. They shouldn't have to. They shouldn't have to, but for a silly ruling from the court. Are there any other questions?
Are there any scenarios where a third-party claim could come into play with the work at home? Like, say you did have a crazy chair hanging from a ceiling that a contractor installed and it was defective.
So I thought about this. You know, right, most homeowners policies exclude personal injury to the homeowner, right? So the person has no coverage and the system is no fault. So you could conceivably, I don't know, I'm thinking about this on the fly a little bit. Could you sue the employee themselves for contribution? I don't think so. Right? I mean, because could
but if you had or renovating your kitchen and tripped over some contractor garbage,
yeah, I would sue the contractor. Yeah, for creating an unsafe hazard in the workplace. Yeah, I would try that. I mean, that's what you could look at as subrogation opportunities. But I think, you know, like the strictly sort of like, you know, I slipped and fell on my own wet floor. I don't know. I mean, you could try and sue your own employee and say, okay, you have a comp claim against us, but you were injured due to your own negligence in your own home, and so we're seeking contribution from you. Does the workers' compensation, does Section 11 bar the employer from suing the employee?
But wouldn't it be as the premises owner?
What if you're not the homeowner?
In their
you have a
capacity
landlord?
as homeowner, yeah. So you sue the landlord, you'd sue, like, if we have this case kind of going on right now. So if wife is injured, but husband is on the title, do we get to sue the husband on a theory of a premises case, even though the worker themselves couldn't, because A, you couldn't sue your spouse, and B, you live there, so you're excluded under the policy. Like, there's no recovery. It's not really a subrogation, it would be a third-party action.
But if you have a landlord and your stairs are rickety and you fall going upstairs to get your coffee, you're not.
Oh, I like that. We should try it. If you get one of these claims, give it to us, and we'll sue the claimant themselves and see what happens.
We're assuming they're all the homeowner, but they're not.
They might not. You're right. Yeah, they might. The board will be pissed as hell. It's like employer sues injured worker, or employer sues landlord. All of a sudden, these landlords are going to be super upset.
Well, you have to make a choice about letting every work at home employee.
Yeah, maybe that means that leases are going to be amended to say that you can't work from home. Or leases are going to be amended to include indemnification provisions that say, if you're injured on the premises in the scope and course of your employment, you have to defend, indemnify, and hold harmless the landlord from any damages as against them.
Mm-hmm.
So you could be in a circumstance, I wish we could figure this out now, but you could be in a circumstance where, because of the chain of claims, the claimant would ultimately be responsible for paying for all of the costs of their claim.
Well, couldn't the landlord just put in the lease that it's becoming an out-of-possession landowner and that the tenant's in complete control of the property and takes care of all maintenance and snow removal, lawn care, those types of things? That way, you potentially wouldn't be able to go after the landowner because he's just collecting a rent check every month.
Maybe, but I don't even know if you can do that in New York, and I don't even think that would be very specific circumstance, like if you were renting a house. You know what I mean? Like, but if you were in an apartment, I don't even think you could claim out of possession landlord because, you know, they're required common area maintenance. Or like a typical, like a Buffalo up and down duplex or something, you know what I mean? It's like, I don't know that you could even do that. Particularly in New York, with as aggressive they are about absentee landlords. But it's a good thought. I mean, I guess you could try and the landlord could try and immunize themselves from liability. I'm not being an expert in that area of law, I don't know whether it would work or not. Is there anything else? All right. Well, it's 26 after. I want to thank you all for your time and attention. We had a great turnout. If you would like a copy of the complete handout, which some of you have already seen, our office does, we do a very thorough handout. Every decision is reviewed in there and discussed and referenced. I think this year, Brennan, it's like 85 pages long.
Yeah.
But we do have a table of contents. It's broken down by area of law. If you would like a complete copy in PDF searchable format, please email Najee Walker at nwalker@madwcdefense.com, and he will provide you with a courtesy copy in the hopes that you will use it to defend and destroy our enemies. Thank you, everyone. Have a great day.
You too.